I'd like to introduce Professor Jane Kelsey from the School of Law at the University of Auckland in New Zealand to speak about e-commerce at RCEP, if I can get the acronyms correct. Thank you.
Kia ora. Thank you for the invitation to be back in sunny Queensland. It's nice to see familiar faces and new faces, and some I haven't seen for a very long time, Lisa. If I had been asked 2 years ago whether I would be talking about electronic commerce, I would have looked with absolute horror at the prospect, because I'm a services and investment girl. But these days, the world of these agreements is changing extremely rapidly, and old borderlines are being blurred. And it is not actually clear, or I think, Burju and I were talking about this morning, it's actually very clear that negotiators don't understand a lot of what they're negotiating in these areas, and they certainly don't understand the connections between what they are negotiating in an area such as e-commerce and the rest of the agreements, where they tend to negotiate in silos with very little understanding of what the overall picture is. So several of us have spent the last 18 months trying to come to grips with what is happening around the electronic commerce negotiations in a number of agreements, including RCEP. This is a quote just from 2 days ago by the Director General of the WTO, where, as I will mention, e-commerce now is also under a very major push to get a formal negotiating mandate on e-commerce agreed at the Buenos Aires ministerial meeting in the beginning of December. But as Azevedo said, when they talk about e-commerce, they're actually not all talking about the same thing. However, the industry knows exactly what it is seeking. And when I'm telling people how to try to understand what is happening in the negotiations, they need to first go and look at what the industry's demands are. Because once we see the demands, we can start to make much more sense of the rules. But what we have, if just stepping back from the rules for a moment, is an awful lot of buzzwords that are flying around, right? We have the notion of the fourth industrial revolution, where the digital technologies are going to have as significant an impact as the printing press and the discovery of electricity did. And we are actually seeing very significant changes occurring. We see reference by the industry especially to new trade routes for the 21st century, the platform economy, the digital marketplace, the Internet of Things, including digitally enabled physical products, but also the IT production of things such as 3D printing and so on, and the digital global supply chains. So all of those are encapsulated in this notion of e-commerce that's emerging, plus a few more. There is at present minimal regulation of the frameworks for delivering those, especially through the internet. And that has been deliberately quarantined by the US in its telecommunications regulations, where it treats telecoms regulation as distinct from internet non-regulation. It has made sure that it is quarantined from the International Telecommunications Union, which makes the big global rules in relation to telecommunications, and of course ensures that there are no global competition rules that are effectively going to constrain the dominance of what is called GAFA, Google, Amazon, Facebook, and Apple, who are very clear that what they want is global rules to ensure that national governments don't regulate their activities. And that is the fundamental basis of what we're seeing in a range of strategies and texts. which are all designed to create a new set of global norms. The intention is to insert into as many agreements as possible very similar frameworks that create this new threshold. And we're seeing it in the e-commerce texts that I'm going to talk about today, but supported by rules and trade and services agreements, commitments on cross-border supply of various services, commitments on computer-related services, commitments that any commitments that are made will be technologically neutral, even if we can't conceive at present of the technology that might deliver them. What we commit to today will bind us in the future. A negative list that basically says we can say now what it is we want to preserve in terms of existing regulation and future policy space, and no regulation of new services, services that don't yet exist, that you can't protect yourself from, but you bind yourself now to allow without restriction. And then the transparency annex, which guarantees the right of the affected interests to comment on any proposed new regulation, which, as we've seen in some of the tobacco areas, actually also provides a basis for developing a compendium of evidence that can be used in investment disputes. So if we look at and this is driven largely, of course, by the US industry, because that's where the GAFAs are based. They have a wish list set out before the change of government last year to the USTR, allowing data to flow freely across borders, prohibits requirements to store, manage, or otherwise process data locally, ensures that the services disciplines, and this was specifically in relation to TISA, services disciplines apply to all services, including those that don't yet exist. Enables open online and cloud platforms by not holding them accountable for what others put on them, and limits the number of limitations that governments can put on these obligations. That was supplemented last month by another letter from, and I just put the players at the bottom there, and you can see all the big players in there, adding a number of other items, which include protection of copyright, but with some safe harbours and exceptions that they approve of. A customs moratorium on e-commerce being made permanent. There is a temporary one in the WTO at present. And eliminating forced technology transfers, in particular to developing countries, and that includes especially the disclosure of source codes, either for specific products or for the algorithms that operate the platforms themselves. And they want a specific representative in the USTR's office. What have I just done to that? Thank you. So it's not surprising that certainly in all the agreements the US has been involved in, we see similar texts emerging. Right? And the ones that we have, the Trans-Pacific Partnership Agreement, unfortunately the e-commerce text was never leaked. And that meant it didn't become a big issue during the TPP itself. However, the TISA text was leaked. It's almost identical in its current form to the TPPA with some disputes. In the WTO, the texts that are now being put on the table for the lead up to the Buenos Aires ministerial follow the same sets of demands, interestingly including the EU and Japan. And from the leaked headings that we saw from RCEP, there have been very few leaks from RCEP, but there was a leak of headings of the e-commerce chapter. It is the same framework that is being proposed for RCEP, which brings in some of the issues that Lisa was raising before. Given that TPPA and TISA have fallen over for now, there is this big push in the WTO, but the WTO is a very cumbersome being, even if they get the negotiating mandate. The positions that have been tabled in RCEP are being led, we believe, and this is based not only on that, but Burju and I have been at a number of the RCEP negotiating rounds talking with negotiators, tabled by Japan. Australia is now becoming increasingly aggressive in the e-commerce negotiations as well. But RCEP is not TPPA. China has a very different focus. And Lisa talked about the One Belt, One Road. It has a digital component. China is committed to establishing digital free trade zones in China and outside China that are a part of the One Belt, One Road. It therefore has a very particular agenda, which is driven by Jack Ma's Alibaba. And if you're thinking about behemoths, Alibaba is as much of a behemoth as GAFA. Yeah? But they talk with different rhetoric, not the liberalisation rhetoric, not the speed of delivery and the satisfying consumers who have demands that they want to be met yesterday, but building an ecosystem for the digital environment across all of those countries, which means the digital platforms, the databases, the financial and logistics regimes and so on, often in partnerships with states. And what we're seeing now is the first of Alibaba's digital free trade zones with Malaysia and the Malaysian government at the Kuala Lumpur airport, which is to be a hub out into the Southeast Asian region, which is causing Singapore some concerns. But is, again, as Lisa said, as much about getting stuff into China and providing the kind of routes that are working for the economic development strategies in China, which are geared towards political stability as well. Prosperous middle class, satisfied consumer middle class is not only good for the consumer economy, but it's good for political stability. India, which is also in RCEP, has its own very different agenda. India, as many of you will know, whether it's in Bangalore or other back office operations, has invested very heavily in building the e-commerce frameworks. It also has been very keen on exporting its personnel to other countries, especially the US. The US has now cut off some of that supply or some of that entry. And India has proposals in RCEP as well as in the WTO for what they call a trade facilitation and services agreement, which includes free flows of data, no requirements for establishing a local presence if you're providing services from across the border, and so on. So there is an interface between what India wants for its own reasons and what some of the GAFA-style demands are. And that means in RCEP, we have a mixture that is contesting the organ harvesting model. Yeah. ASEAN's views are mixed. You've got some TPPA parties who've already signed up to stuff but are now temporarily off the hook, hopefully permanently. You have some, and I'm doing a project at the moment for an ASEAN think tank of some believe it is going to create new supply chains for them and opportunities for their SMEs and so on, which is not going to happen. And some of them are nervous but actually don't know what it means. Frank, can you give me a 3-minute warning? So let's have a look at what we understand is in the texts. And I'm happy to make the slides available because I'm not going to get through them all. But I group the texts, which, as I said, are pretty much the same across all the agreements, we think, including what's been tabled in RCEP, into 4 substantive elements. The first is the most important, which is the rules that prohibit national regulations of digital frameworks, platforms, and transactions. The second is very weak privacy and consumer rights. The third is very strong state security powers to override the agreement, or the chapter or the annex. And the fourth is the actual e-commerce stuff of dealing with things going across the border for commercial reasons, and that's a micro part of the chapter. It's not clear whether e-commerce will exclude government data, whether it will exclude financial services, whether it will exclude services and grants, whether it will exclude government procurement, even on the very limited definition in the agreements of procurement that is for the internal purposes of government entities, and it's unclear whether governments will be allowed to schedule any exceptions to these obligations. I just want to highlight a couple of the really important rules. When I was talking about prohibiting national regulations, they go back to the internet industry's demands. They want to prohibit regulations that require that information, data, is stored and processed inside the country. Now, that creates all sorts of big issues. Especially issues of who controls the data, how you'll get access to the data at a time of crisis, especially if it's financial data. But also, we know that this is worth an awful lot of money. And there is a great deal of money being made out of the sale of data of which people have no control. Transfer of or access to source code. Now, one of the interesting things in China when I was up there recently was that China wants to get heavily into artificial intelligence, but and more use of robots. But the three main components they have to import, which make it very expensive in comparison to other countries, unless they can get the source code. And so the source code, in a broader development sense, actually becomes part of the old technology transfers that we used to hear in the development infant industry kind of arguments. Use of local computer facilities. They don't want to have to use your local computer facilities rather than the big mega mainframes that they have off at home base or somewhere else. And that has serious consequences, again, for a number of developing countries especially, but not just them. If the big players aren't going to be using your local computer facilities, why are you going to invest a lot of money in developing those computer facilities? Especially if your local providers are going to be facing cutthroat kind of competition from the big players who are delivering from offshore. And I had some discussions in Uruguay with them on this because they've just made a massive investment in top quality broadband and developing an infrastructure there. And they're really concerned about what they saw as their competitive advantage that they were going to create through this infrastructure being eroded if they can't actually require use of those local facilities. There's also things in the telecoms chapters that I'm not going to talk about that link across to this. There is a prohibition on requirements to use local content in electronic transmissions. Now, that's thought about most often in the culture and entertainment sector, but it also includes, for academics, real issues around education services, the MOOCs and other online products, but increasingly if you're looking at delivery of services from offshore, then that becomes significant. But it also becomes significant for development reasons in that your local players don't actually get any guaranteed role in these services, cross-border services supply chains. And they don't get to develop the skills and the knowledge base and the experience to be able to build the local economy, especially if you can't require the performance requirements for technology transfer if they are required to actually set up inside the country. And whilst there tend now to be exceptions for requirements where you hire local personnel, that doesn't apply if it means transferring any proprietary knowledge or technical specific technical knowledge. Right? So this is a bit like the old colonial regime where we make the rules that allow not the East India Company but the gaffers to do what they want. But of course the industry rhetoric calls all of those measures protectionist and forced localization and appeal to freedom of the internet, not the oligopoly of GAFA. So I've just dealt with that. The source codes issue is really interesting. And we found out that, in fact, the reason it's in the e-commerce chapter rather than the intellectual property chapter of TPPA is that if it had been raised in the intellectual property chapter, it would have created merry hell, and they were having problems enough, and it got put into the e-commerce one because it's basically trade secret stuff, and no one in e-commerce really understood very much of it. But giving absolute monopoly rights on the source code creator creates problems about how you check compliance with standards, how you check protections on hacking and malware, how you deal with financial risk and fraud. And I've written some things that spell these out in much more detail. How you deal with abuse of information like dynamic pricing or profiling of users and so on, because those are done by the algorithms, and restricting your ability to have your repairs and components industry being able to play a role if they can't access the source code. Now, there are, as I mentioned, cross-fertilizations to a lot of the services rules, but the one I wanted to finish on is about the privacy and consumer protections. The agreements that we've seen have minimalist requirements, and minimalist is an understatement, on online consumer protection, personal information protection, which is basically privacy, unsolicited spam, and access to the internet and open networks subject to reasonable network management, which is undefined. It's unclear exactly what the standard will be in RCEP. One of the problems talking to developing countries in RCEP is that they don't have these rules yet. So we have had reasonably robust debates around privacy and consumer protection and so on. If the requirement is that you adopt these kind of rules, but they're minimalist, and if you get challenged for them being more than minimalist, that is more burdensome than necessary to achieve their objectives, then you're going to have some problems. And that brings me to my final point, which is the general exception in all of these agreements. The general exception, as we know, for those who are trade lawyers, is full of difficult steps to pass, right? So we have now 2, we're assuming with Australia's tobacco case, 2 out of 46 times it's been used in the WTO actually being fully successful. Right? So it is a very hard test. And that's for health and for environment and public order and so on. But I invite the lawyers to go and have a clear look at the consumer protection and the privacy provisions in there. They only apply for consumer protection to fraud or default on services contracts. Right? They don't apply to use of data or other kinds of lack of compliance with consumer codes and so on. And for privacy, they relate to processing and dissemination of an individual's data, but not use or storage of the data. But the problem is, not only are they limited, but it only applies where the law or regulation that they're implementing is not inconsistent with the agreement. That is, the agreement allows you to have the law, and this exception deals with measures to implement what the agreement already allows you to do, but it gets worse. It must still meet what we call the chapeau of not being arbitrary or unjustifiable discrimination by countries or in between like countries, basically, or a disguised trade restriction. So the measures to implement the law that you're allowed to do under the agreement must meet the chapeau, and it must be a measure necessary to implement the law that you're allowed to have, which means it's actually an additional restriction on your ability to pursue privacy and consumer protection provisions, not an exception, which is why there is going to be a major debate around these issues in all of these arenas, including RCEP, because the negotiators are now aware of this, and it needs to become a big domestic issue because not enough attention's been paid to it. Kia ora.